FISA requires probable cause that the target is an agent of a foreign government. Once FISA issues the warrant, then the government can listen to the conversation of the foreign agent. Example, if it turns out that the janitor in the Soviet embassy is really a spy who beats his wife, he cannot be prosecuted for domestic violence because the information was obtained from a FISA warrant, inconsistent with the Constitution, and he can't be prosecuted for espionage because the information was obtained from a FISA warrant, inconsistent with the Constitution. The only thing the government could do is deport him. In 1978, not satisfied with the lessening of the probable cause standard, the Congress enacted something called the Right to Financial Privacy Act. Well, you know what's coming. You know the way the government names these statutes. If it has the word privacy in it, bet the mortgage you're going to lose some privacy. The Right to Financial Privacy Act brought us full circle to the Writs of Assistance Act, because this abominable statute permits government agents to write their own search warrants and to serve them on financial institutions. The target is limited to a financial institution, and the custodian of the financial institution must tell you about it. So if an FBI agent decides to write a self-written search warrant on the bank where Nick Gillespie deposits his billions, the bank would be required to say, hey, Nick, there's a guy here. He's from the FBI. He gave us a self-written search warrant. We're going to comply with it in about 10 days, but you have 10 days to challenge it, to go to a judge and say, what is this nonsense about a self-written search warrant? I have my Fourth Amendment rights. That was the rule set down in the Right to Financial Privacy Act. But even the big government people who disrespected the Constitution, who hated the Fourth Amendment, who wrote the Right to Financial Privacy Act, understood that any evidence obtained from one of these self-written search warrants could not be used in a prosecution against the target in my hypothetical, the great and the wonderful and the handsome and the devilish. You want me to keep going? Nick Gillespie. Because the evidence was obtained on less than probable cause of a crime, it was obtained inconsistent with the Fourth Amendment. All of this sets the table for 9/11. Now, wherever you were on 9/11, you cannot forget or underestimate or overstate the catastrophe that occurred to the 3,000 human beings that died, to the American psyche, to our feeling that we are free and will always be free and no one can take our freedom away, to the government and to the Constitution. Because the government's initial reaction was to author the most abominable piece of legislation since the Alien and Sedition Acts, with the most unlikely of names, the Patriot Act. The Patriot Act is the most dastardly direct assault on human liberty and on guaranteed rights in the Constitution that the Congress ever enacted since the Alien and Sedition Acts 200 years earlier. The Patriot Act was enacted with no debate on the floor of the House of Representatives. Ask your member of Congress how much time he or she spent reading the Patriot Act. I've read it. I've read it twice. It's 315 pages long. But in order to read it, you must have with you and in front of you the entire United States Criminal Code, because the Patriot Act doesn't read like a novel or like a nation of sheep. The Patriot Act says, on page 362, change the semicolon to a comma. On page 467, change the word or to and. Change 15 to 10. So in order to read this, I'm just giving you hypotheticals here, you must insert the language from the Patriot Act into the many, many volumes of the United States Criminal Code before you can actually figure out what the Patriot Act says. The Patriot Act was posted on the House of Representatives intranet That's their internal internet that only members of Congress and their senior staff have access to. And the House members were told they had 15 minutes to vote on this dastardly assault on human liberty. Well, what did the Patriot Act do? Why am I so animated about it, whether there was debate or not? Nobody in the House read it. 2 members of the Senate read it. One of them is dead. Congressman Paul Wellstone said he read it. He's dead. It's Senator Russ Feingold has stated publicly that he read it. The 2 people that read it, of course, voted against it. Nobody else read it in its entirety. The Patriot Act allows the FBI, your FBI, those men and women sworn to protect the Constitution, to invade your home while you're at a basketball game on a Friday evening or a football game on a Saturday afternoon or church on a Sunday morning and make it look like it was a robbery. Well, what is this? You call the local police and say my house isn't broken into? The last people in the world you would suspect would do that would be your local FBI, but they can do it. And they can plant a listening device on your bedpost or under your kitchen table or in your shower or anywhere in your house that they want without taking anything. By the way, if they want, they could also take your checkbook because they may want financial information about you and you not knowing that you have it. And if they serve one of those self-written search warrants under the Patriot Act on your bank, let's continue with our hypothetical with Nick Gillespie. They now, after October 15, 2001, send a self-written search warrant. No judge is involved. Forget about the Fourth Amendment, the president has said. It takes too much time to preserve human liberty. Too much time to remember these are natural rights, as natural as the fingers on the ends of our hands. But the Patriot Act says if the self-written search warrant is served on Gillespie's bank, it is a crime for the bank to tell him. Well, wait a minute. What about the First Amendment that says Congress shall make no law? What about the Fourth Amendment that says if you want evidence from someone, you got to go to a judge? The Patriot Act wipes that out. Not only may the evidence be used, remember Carter and his buddies when they wrote FISA, when they wrote the Right to Financial Privacy Act in 77 and 78, says right in the statute, can't be used as evidence in a criminal case. The Patriot Act says whatever is obtained from one of these self-written search warrants must be used as evidence. The first time I've seen that in any statute I've ever read. Must be used and must be admitted as competent evidence in a criminal case. So the Patriot Act brings us full circle from the reasons for which, at least the last straw about which, we broke away from the mother country. The king and the parliament told the British soldiers they could write their own search warrants and use the fruits of those warrants against us in a criminal prosecution. And the Congress has told not just the FBI, but all federal agents that they can write their own search warrants, serve them on a financial institution, use the evidence obtained against you, and make it a crime for the financial institution to tell you. It's even a crime for the custodian, the person at the financial institution, to tell anyone that he or she has received a self-written search warrant. So the banker can't tell her husband, her lawyer, her significant other, a priest in the confessional booth, can't even tell a judge in a federal court. That's why these challenges, when there are challenges, are always John Doe or Mary Roe versus John Ashcroft.